Welcome to our monthly Ask the Experts webinar series, where we bring professionals to share best practices and cover important information topics to help our board members. My name is Kathy Wade. I am the COO for CAMS Management. While we're waiting for folks to jump on, I'm going to share a couple things with you. Our goal at CAMS is to be the information source you can turn to as board members for your associations. Make sure to check out our CAMS website, where you will find up-to-date resources to help you with your role as a board member. We are always updating our blog, which is filled with articles and tips. We post these webinar recordings of each session on our website. You will also find case studies showing examples of situations that boards have encountered and that may help you as you serve the community. There's also a board toolbox with documents, how-tos, and much more. And the link to the CAMS website will be sent to you as a follow-up to this email. This year marks our 30th anniversary serving community associations. In celebration of this achievement, each attendee's name will be entered into a drawing for a $100 Amex card. The winner will be notified by email, and we do announce that winner in the following webinar. Congratulations to last month's gift card winner, Reggie Robinson, who is a board member with Courtside Condos in Charlotte. And thank you for serving your community, Reggie. So it looks like we're almost ready to get started. Our speaker today is Michael Taliercio, who is a partner with law firm Carolinas. Michael specializes in community association law, bankruptcy, parliamentary law, civil and business litigation. And these are all very complex topics. So we're very thankful for you to give us your time today, Michael. Thank you.
Kathy, thank you so much. Everybody, I'm really happy to be here. Again, my name is Michael Taliercio. I'm a partner at law firm Carolinas. I oversee our bankruptcy and collections for homeowners associations. And today the presentation is called Bankruptcy Basics, basically like a 10,000 or 20,000 foot view of what bankruptcy is and what you all need to know about bankruptcy. So let me just share my screen. I've got a slideshow here. Give me 1 second. And all right. So again, this presentation is called Bankruptcy Basics. Now, what we're going to be talking about today are a few things. First, why people file bankruptcy, a general, very summarized version of the bankruptcy process, who the main parties are in bankruptcy, why people file bankruptcy, and what protections the bankruptcy code gives somebody in bankruptcy, the two main types of personal bankruptcy, and then what you as an association shouldn't do in a bankruptcy case, what you should do in a bankruptcy case, talking about filing a claim in bankruptcy, and then other things that come up in bankruptcy. At any time, please put your questions into the Q&A, and Kathy's going to interrupt me if you all have questions. Do we already have questions?
Mike, we can't see your screen yet.
You can't see my screen?
Yep.
Oh.
So there we go. It's come up. And as Michael said, please, if you have questions, let us know and we will get those answered for you.
Can you see it now, the splash screen that says Bankruptcy Basics?
Yes, thank you.
Okay, great. So sorry about that. Here is, here is kind of the summary of everything we're going to be going over. So let's just dive right in. Again, stop me at any time if you have questions. So first, in terms of where bankruptcy comes from, it's in the Constitution. Article 1, Section 8, that's the clause that Congress can establish uniform laws on the subject of bankruptcies throughout the United States. Bankruptcy is federal. In terms of, has Congress done this? Yes, numerous times. You know, they have had originally the Bankruptcy Act. It was changed into the Bankruptcy Code. In 2005, they passed the Bankruptcy Abuse Prevention and Consumer Protection Act. And then as recently as last year, they changed the Bankruptcy Code through the CARES Act. So bankruptcy, you know, Congress is constantly tinkering with this, but that's where this comes from. Now, why people file bankruptcy? The top reason, they've done a lot of studies, is medical bills. You know, more than 70% of bankruptcy is the key factor is medical bills. Other big reasons are, you know, income loss through either a business that's failed, somebody's been laid off from their job, or they've been divorced or some other family situation. Then finally, people will file bankruptcy. The other big factor is if they're facing foreclosure on their house. They'll file bankruptcy to attempt to prevent the foreclosure, which when I start talking about, you know, the protections, there's a way that they can prevent foreclosures through bankruptcy in some situations. So that's why people do that. Now, in terms of how common is bankruptcy, these are the bankruptcies. The federal courts keep detailed statistics on bankruptcies filed every year. These are personal bankruptcies that have been filed in the last year. You can see that it's about 750,000 bankruptcies are filed each year up until last year, where there was about a 30% reduction or so in the number of bankruptcies filed. You might ask yourself, why were there so many fewer bankruptcies filed last year? The kind of the reasons that bankruptcy lawyers think are first because of you know, the CARES Act and the various unemployment protection relief that people were given and the additional money that people were given. People who lost their jobs had a better cushion where they didn't have to file bankruptcy. You know, they could use unemployment. And then also the CARES Act and some other federal mandates prevented banks with federally backed mortgages from pursuing foreclosures against people. And as you saw in the last slide, foreclosures is one of the big reasons why people file bankruptcy. So if banks weren't pursuing foreclosures, then, you know, people weren't having to turn to bankruptcy. But still a lot of bankruptcies, 500,000 bankruptcies. So it's not uncommon that you might have to deal with a bankruptcy case while you're on the board of directors, that somebody that in your community files bankruptcy and you might get those notices. So this presentation is kind of give you what's happening and what to do. In terms of how a bankruptcy works, to give you basically the 2-minute summary, there's an initial filing. That filing, once they do it, it's called a petition. Once they file the bankruptcy petition, they have a case and all the protections of the bankruptcy code go into effect. I'll get into those shortly. In that petition, they have to give a lot of information to the court. I mean, the packet is, you know, like an inch thick or larger. I mean, it's filed electronically, but if you print it out, they have to give a full disclosure of their assets and liabilities, their incomes, their debts. In theory, they need to notice all their creditors. They need to notice anybody that they have debts with. They need to notice their business partners. It's a complicated process. Once they do that, then there's a bankruptcy trustee who is a lawyer appointed by the court to administer the case. What exactly they're doing depends on the chapter. And then there's a creditors meeting where that lawyer and in theory creditors can meet with the debtor to ask them questions about their case. And then there's appropriate bankruptcy hearings. In liquidation cases, those hearings are usually about selling assets and distributing money. In reorganization bankruptcies, those hearings are about approving the plan in the bankruptcy to achieve the reorganization. Now, the final part of the bankruptcy is the end of the bankruptcy. It's called the discharge. And this is if you successfully complete everything, this is where you don't have to pay certain debts ever again. And I'm going to talk about the discharge in a lot more detail in a minute or two. but that's the final part of the case. If you complete everything else in the case, then you kind of get that write-off on your debts that you're looking for. In terms of the different parties in a bankruptcy case, the person filing the bankruptcy is called the debtor. Generally, that should be represented by an attorney. I've seen pro se bankruptcies. I mean, bankruptcy is complicated for lawyers. Not all lawyers do this or know anything about this. So representing yourself in a bankruptcy case is a difficult thing to do at best, and usually results in the bankruptcy case getting dismissed from bankruptcy court, just kicked out of bankruptcy because the person doesn't do it right. The trustee, this is a lawyer. Every bankruptcy case has a trustee. Their job is basic. They're appointed by the court. Some are generally, there's like a list of standing trustees and they're determined randomly. Or there might be one standing trustee for certain chapters. What they're going to do is they review the documents, that bankruptcy petition that's been filed by the debtor, that's filed by the person that's in bankruptcy, and determine if it's a liquidation bankruptcy, they determine if there are any assets that they can sell to get money to pay creditors. And then two, or if it's a reorganization bankruptcy, they kind of are the dispersing agent, as well as they make a determination if certain monies have to be paid in according to the bankruptcy code. They determine if legally the person has kind of checked all those boxes. Everybody else is a creditor. Your association is going to be a creditor. And the other thing is about bankruptcy is it takes a very broad view of what a debt is. A debt is not only a current obligation to pay money. It's not just, a credit card bill or a medical bill, or, you loan somebody money. Any future obligation, bankruptcy code will view as a debt. So the fact that somebody's living in an association, and they might be current on their dues now, but in the future, they're going to owe more dues and owe more assessments for their condo or their house, you're a creditor. Your association is a creditor because in the future, they're going to have to make more payments to you. So they should be noticing you on their bankruptcy case. Now, they probably won't, but they should. So we're going to talk about protections. This is the first protection in bankruptcy and perhaps the most important, the automatic stay. It goes into effect immediately upon the person filing bankruptcy. It's what's known as the automatic stay. And it halts all attempts to collect any debt that's owed as of when the case was filed, as well as any attempt to exercise control over the debtor's property. So, for example, if the debtor didn't pay on their car loan and the car company is trying to repossess their car, as soon as they file bankruptcy, they have to stop doing that and get permission from the bankruptcy court to repossess the car. Or if their bank is foreclosing on their house, they have to stop and get permission from the bankruptcy court to continue that foreclosure. You see, kind of my third thing there is that violations of the stay are punished. This is probably a big understatement. Violating the bankruptcy stay, I mean, this is one of the fundamental protections of bankruptcy. This is what every creditor should be scared about, that if they continue a lawsuit or keep sending letters for somebody to pay a bill while they're in bankruptcy, the person in bankruptcy can file a lawsuit against them for violating the stay, and they can get attorney's fees, emotional distress, any other actual damages. I mean, there's a lot of cases. This has been litigated heavily. There's a lot of cases where somebody was going after somebody in bankruptcy over, a few $1,000s that they owed on a mobile home, and they winded up getting improperly, and they winded up getting sued by the debtor for tens of thousands of dollars.
So, Michael,
yeah.
For the homeowner association, then what the stay means is we need to stop sending letters to the debtor. But
Yes.
you also mentioned that they might forget to notify us. So what does that mean?
So it's not, if they didn't give us, usually, if they didn't notify us of the case, there's kind of nothing we can do, right? We're going to keep sending them statements. And usually in most ongoing bankruptcy cases, there'll be a provision, we're going to talk about Chapter 13 in a second, which is your kind of your ongoing long-term bankruptcy reorganization for consumer. Usually there's a provision that you can keep sending periodic statements to the owner during the case. But if they didn't notify you of the bankruptcy case, that's going to be a defense when when they're going to try to seek sanctions from you for violating the stay, which realistically, they're not going to do that after just one letter. Probably what will happen is if they get a letter in the mail from your association that says, hey, you owe ongoing dues, you might get a letter back from their bankruptcy attorney saying, hey, they're in bankruptcy. You can't send these collection letters to them. And then what you should do is you say, okay, and you should give that bankruptcy letter to me, and I'll take the appropriate action in the bankruptcy case, which is usually filing a claim. Does that make sense?
Yes, and sometimes they will file bankruptcy, but they will not include the association. You mentioned that the association is a debtor because of the future obligation.
Right, yeah. The association is a creditor because of the future obligation. Yeah, so, but many people, they won't include, and here's the other thing. Sometimes you might not, the best case scenario is the dues are on auto draft and they just keep paying the whole time and you don't even know they're in bankruptcy, which is great. If they're current in bankruptcy and they don't complain about you sending statements and they keep paying, okay, then, no harm, no foul, kind of, because they never provided you any sort of notice they were in the case and they never complained that you were sending them those statements. But what happens, what is not uncommon, is that they forget to include the homeowners association. And then while they're in bankruptcy, they assume they don't have to pay you. And then a year later, you refer the account to a lawyer like me for collections, and we discover they're in bankruptcy. That happens frequently. The other, and here's the one that I'm going to point out right now, is when they talk about what an attempt to collect a debt is, we obviously a letter demanding money is an attempt to collect a debt, but they view this very broadly. When they file bankruptcy, you're supposed to treat that account as current. And so if your association, say, has amenities like a pool, and in the spring, everybody who's behind, you'd suspend their access to the pool. You do like a hearing and suspend their access to the pool because they're behind on their dues, which usually, in my experience, results in a whole bunch of people paying because they want to use the pool, right? But you suspend everybody's access to the pool. Well, if they're in bankruptcy and the only amount they're behind is the stuff from before they filed bankruptcy, you can't suspend their access to the pool. You have to treat them as if they're current from when they filed bankruptcy. And the bankruptcy court is going to look at that attempt to suspend their pool access as a violation of the automatic stay, because they're going to think that you're trying to collect a debt, even though you're not sending them a demand for money. You're just saying you can't use the pool. So it's viewed very broadly by the bankruptcy court. The bankruptcy court, and I'm going to mention this many times, it exists to help people filing bankruptcy. That's its job. It's the most pro-debtor place, kind of, period. So, unfortunately, being a creditor in bankruptcy is just not a great place to be generally. Now, what is the bankruptcy discharge? This is the other big protection in bankruptcy. This is the debt write-off. If they complete everything they need to in bankruptcy, the debtor gets a release of all the personal liability of the debts included in the bankruptcy. And similarly, if you don't write off the debt that you need to write off, they can file the same sort of lawsuit as for violating the stay, for violating the bankruptcy discharge. Now, what debts are included in bankruptcy? It applies to the amount of debts as of when the bankruptcy was filed, but only to personal liability. not to liens. So what this is basically, when I guess the easiest way to explain this is think about when you buy a house. When you buy a house, you sign a promissory note that says, I'm going to personally repay you, Bank One, this, $200,000 for my mortgage. But then you also sign a deed of trust or a mortgage that's filed with the Register of Deeds that goes against your house. So the bank, if you don't pay, they can sue you on that, note that says you personally owe the $200,000, but they can also foreclose that deed of trust. Well, what bankruptcy does is it eliminates your obligation on the note. That personal obligation for anything that was owed when you file bankruptcy goes away, but the deed of trust doesn't. So any sort of lien, a deed of trust on a mortgage, a car loan, a homeowners association or condo association lien, all of those will survive bankruptcy, which, to jump ahead, and just in general, is why you should try to get liens on accounts that are behind, because you're going to be in a better position in bankruptcy. And just generally, as somebody who has done thousands and thousands of collections cases, it goes better if you have a lien. And that lien will not be eliminated. However, the personal liability is. And then finally, there's also exceptions to the bankruptcy discharge. Not every debt is discharged. Child support's not discharged. There's a lot of tax debt that's not discharged. And exceptions exist. I could frankly talk for an hour about the exceptions. There's a fraud exception. There's an embezzlement exception. There's criminal restitution exceptions. There's all sorts of exceptions. And some exceptions you get automatically. Some exceptions you have to file a lawsuit in bankruptcy to show that the exception applies. That's beyond the scope of this. You should be aware that there are exceptions that pertain to homeowners associations and condo associations, most notably for dues that come owed after the filing date of the bankruptcy petition, which is known as post-petition dues or post-petition debt. Anything that's owed before the filing date called pre-petition. And then for ongoing debts. So debts where you're going to have to keep paying the obligation after the bankruptcy is over, which is what, your assessments that you owe to your homeowners or condos association are, right? You're going to have to keep paying those forever, or for as long as you own the property anyway. So kind of let's talk about then the two kind of the chapters of bankruptcy. There's the two main consumer chapters of Chapter 7 and Chapter 13. There's also Chapter 9, which applies to municipalities. Chapter 11, which you've heard of, that's a business reorganization. It doesn't really apply to consumers. That's, like what General Motors or Ford or American Airlines used when they filed bankruptcy. There's Chapter 12, which applies to farmers or fishermen. And there's Chapter 15, which applies to bankruptcies that cross borders, international bankruptcies. Don't worry about any of that. The two that you might have to deal with are 7, liquidation, 13, consumer reorganization. Now 7, most Chapter 7 cases are no asset cases. So see the information in that gray square there? That's what applies. It's a quick case. It takes, probably about 6 months. Creditors don't file claims. They don't file documents with the court showing, how much they're owed, because nothing's going to be paid out. The way it works is once they disclose all their assets to the bankruptcy court, under federal law, as well as North and South Carolina law, you're allowed to keep a certain minimum number of assets, even filing bankruptcy. North Carolina, you're allowed to have up to $35,000 of equity in the house, $3,500 of equity in the car, and all these other things. If your assets are less than those minimums, then no money gets distributed to creditors. It's a no asset case. So your debts are going to get wiped away, the unsecured debts, and the case will be over very quickly. Basically, in those, the trustee in the bankruptcy is just confirming that there's no real assets to distribute. Asset cases, the kind of the notes below that gray box last much longer. Usually they last a couple years. There'll be a notice that goes around once they discover assets for creditors to file claims. That would be when your association would get a notice in the mail that they discovered assets, and then you'd file a claim showing how much you're owed, and then how much you're paid. It varies very, very widely. If, say, there's $100,000 of unsecured debts, medical bills, some homeowner association dues, some credit cards, and the only asset is, a boat that's maybe worth $5,000, an old fishing boat. Well, once that gets sold, say they get $4,000 for it after, auctioneer fees or something, everybody's getting 4 cents on the dollar. Versus, say they discover that the person filing bankruptcy had a second house that they were willing to give up. And in fact, the second house in this real estate market is substantially valuable. And they're, after paying off whatever debts on the house, able to sell it for $75,000. Well, then, you're going to get a distribution of like 75% of your claim. Now, the reason why that time is so long, though, is this process is very time consuming. It takes them probably 6 months or so to just determine if there are any assets. Then they have to sell or collect all the assets, and then they distribute the assets, which usually there's the bankruptcy code requires all sorts of notice to do everything and all sorts of hearings in court. So it just drags on. But 2 to 3 years, probably you're going to have a Chapter 7 asset case would be completed. I would say for Chapter 7 cases, only maybe 1 in 20, maybe 1 in 10 have any assets. The vast majority are no asset cases. However, the other chapter, Chapter 13, your consumer reorganization, these are the bankruptcy cases that you might be familiar with if somebody in your community is in bankruptcy and you keep seeing on that AR spreadsheet that they're still in bankruptcy. That's Chapter 13. Chapter 13 is a consumer reorganization. Basically what happens is, rather than a Chapter 7 where you disclose all your assets, and if you have excess stuff, the stuff gets sold off for money to pay the creditors. In a 13, you keep all your stuff, and then you have to pay the creditors a certain amount of money, which is at least equal to what, had you filed a Chapter 7, what assets you'd have to distribute into Chapter 7. Usually it's more. For homeowners, so the minimum amount of time you can do a Chapter 13 in is 3 years. Usually they last 3 to 5 years, but you see how I put the time that it takes 3 to 7 years? That's because the CARES Act that was passed last year allowed bankruptcy cases that were ongoing in that time during COVID to file a special extension to extend their case an additional 2 years. So there's some bankruptcy cases that are going on right now that are going to last 7 years. Now, the creditors need to file their claims at the start of the case because, if you're owed ongoing amounts, you're an association, you're a mortgage company, part of the job of the Chapter 13 trustee is to disperse the money to those ongoing debts. Your homeowner association, your car loan, your mortgage, those are the big three. So in terms of a big comparison between the two chapters, Chapter 7 cases, they're very fast cases. Mostly they're no asset. Usually they're over quickly. But because it's a liquidation, you can't catch up debts that are in arrears. If you were behind on your mortgage when you filed bankruptcy in a Chapter 7 case, you have to either surrender the house, give it up for foreclosure, or maybe sell it if there's equity, or you have to come up with the money to pay off whatever you're behind, which you're not. If you had the money to pay off your mortgage arrears, you wouldn't be filing bankruptcy, So in non-asset cases, like 6-month cases, there's not really a lot for an association to do other than to wait for the case to be over. Now, There are things you can do, but a lot of times it's not cost effective because the case can be over relatively quickly anyway, and going into bankruptcy court is not necessarily the fastest process. Versus Chapter 13, these cases last a long time. I mean, 3 years at the minimum, and now some up to 7 years. That is a significant amount of ongoing assessments and potentially special assessments and other things that person might need to pay to your association during the bankruptcy. So this is why it's really important that a claim is filed with the bankruptcy so that you can get the proper amounts. Now, in a Chapter 13, the debtor can do more. They can stop foreclosures in the Chapter 13 because they can pay things back over time, and they can also, they have a better chance. Whereas in the Chapter 7, it's a liquidation. The Chapter 7 trustee is going to sell your assets, right? They're going to hire an auctioneer, hire a realtor, get things sold immediately. In a Chapter 13, what can be done is you can stay in your house, you can be making extra payments to try to sell your house, but in a hot real estate market like now, if you get a good offer on your house, you can then change your Chapter 13 plan and sell your house. And a lot of people see this as a way that potentially they can do better. They can on the sale of their property. The key takeaway for associations is that you need to file a claim to get paid your ongoing amounts. So those are the two big chapters. In terms of kind of takeaways, what not to do, what to do. Okay, what you shouldn't do is nothing. And if you get bankruptcy notices, you shouldn't just throw them away, even if you just assume that you're not going to get paid. You might well get paid. There might discover assets. You might be able to recover something on a debt that you didn't think you would recover. And also, you can't ignore the case. The bankruptcy stay happens automatically when they file bankruptcy. And then at the end of the bankruptcy case, if they complete it successfully, that discharge applies globally to all their creditors, including the association. So you're going to have to write off the appropriate amount of debts, even if you don't want to. Even if you don't think it's right that they filed bankruptcy, unfortunately, this is what federal law allows, and this is what you got to do. Otherwise, the person that filed bankruptcy can bring pretty ruinous lawsuits against creditors that either ignore the bankruptcy or don't properly, discharge the amount of debt that should be discharged. Now, what you should do in bankruptcy cases, first, have somebody review the case. Get those documents to your property manager, and hopefully they'll give them to your attorney. I review plenty of bankruptcy cases all the time, and your attorney can advise you. You don't necessarily, on your own, need to know what chapter it is, need to know whether or not there's going to be a distribution. That's not my advice here, because frankly, that isn't something that, I'm going to have to analyze the case to figure out. That's not something that just a random person who doesn't have any experience with this could really know. Or frankly, that's not something that my partners who don't practice bankruptcy would try to do. They would give it to me and I would review the case. So get an attorney to look at the bankruptcy case, just to make sure that, okay, it's a Chapter 7 no asset case, there's nothing to do here, or it's a Chapter 13 case, there's going to be a substantial distribution. They have some rental properties they're selling. We're going to get a big payout on this claim. We need to do a claim. And, over here on your screen, you can see kind of the first page of the proof of claim form. Have your attorney file a claim, right? And filing a claim is not all that complicated. Here's the basics. Basically, you're usually going to have to do this at the beginning of the case. There's a form that you fill out and your attorney can fill it out for you. And then you have to provide documentation of the amount of it, which for most associations is an account ledger, a copy of the declaration or the covenants showing that the person's in the association and that they owe, that it provides for assessments. And that's basically it. I mean, if you're already in court with the person, you have a judgment, you're doing a foreclosure or something else, you might include those documents too. But it's not a complicated thing to file. You're basically just giving the court and the bankruptcy trustee proof that yes, you association are owed money. I mean, I would say the cost to do one of these, we're talking a few $100s tops. Now, some of the cautionary things, though, is you see where I say it's not a flexible deadline. I'm probably understating that. It's a pretty harsh deadline. If you get notice of the bankruptcy and you don't file a claim in a timely manner, what's going to happen is, well, if you don't file a claim at all, they're not going to pay you, okay? You have to have filed a claim to get paid anything if they're distributing money. But if you do file a claim, but you miss the deadline, which the deadline is, within the first few months of the case being filed, and you file a claim late, well, then the court is likely going to view it as an untimely claim, which there's a hierarchy of how claims are paid. And I'm not going to go into the whole thing, but basically, like the claims for administration of the case are first, then like child support claims are after that, then certain tax claims. Then at the very bottom, almost at the bottom, is your unsecured claims, right? So your typical association or condo dues that don't have a lien that were timely filed. Beneath that is your untimely filed claims if they get paid at all, which a bankruptcy case that pays all of the unsecured claims before and then has money left to pay the untimely claims, extremely rare. It's like a unicorn, never happens. So if you don't file a timely claim, you're probably not going to get anything. And then in terms of on the requirements, say you file a claim, but then you discover that you didn't include the right documentation or more is owed, that's okay. You can amend your claim later. You can change it later as long as you filed a timely claim. The big thing is that you need to file a timely claim. Now, finally, under costs, I also put limited attorney's fees recovery. This is because the bankruptcy court, one of the things it does is polices all claims, all attorney's fees from, the debtors, how much the debtor is being charged by their own attorney, to how much creditors, if creditors are allowed attorney's fees under, your mortgage or your contract or your homeowners association, if you're allowed to collect attorney's fees from the debtor, well, the bankruptcy code has a lot of rules in terms of what fees you can get and what fees are reasonable and what fees are going to be paid. And generally, that's going to limit the amount of attorney's fees that you can collect in a bankruptcy case. So a lot of times you're going to be out of pocket for having to take action in a bankruptcy case. You're not going to be able to get your attorney's fees. Whereas, in most collection cases, right, just your average dues collection case in state court, you can ask to get your attorney's fees if your documents allow it, which almost every associations do. That is not always the case in bankruptcy, but that is kind of an across the board thing. Like banks are operating in under the same restrictions, that they can't necessarily get all their attorney's fees either. I mean, it's not really very fair because obviously banks have thousands or millions of times the assets that the average association does. But this is why, but that's just kind of how it is that, bankruptcy is sort of a one size fits all program, and banks are operating under the same restrictions that associations are. Any questions so far before we get to kind of other things you can do in bankruptcy other than filing a claim?
No, we don't yet have questions, Michael.
Okay.
I did wonder, you mentioned that the debtor can be discharged.
Right.
And then what are the conditions where the bankruptcy is dismissed?
Oh, okay. So good. Also here, we'll So actually, there's a lot of conditions. In that Chapter 13 case, right, where you have to make a plan and you have to do certain things, the main thing is you have to pay every single month a certain amount of money. If you don't pay the money you're required to pay into the bankruptcy court, you're going to get dismissed. But there's a number of other requirements. You have to do credit counseling. You have to pay your taxes timely. You have to go to certain meetings or court hearings. If you don't do those things, you can get dismissed from the bankruptcy case. And one of the other options is you can, in theory, it's not listed here because it's rarely done by associations, but creditors can ask for people in bankruptcy to be dismissed from bankruptcy through misconduct. It's rare for it to happen. I would say most of the time. Well, so first, let me go back. So this slide, right? There are 500,000 bankruptcies filed last year. Of those, 70% were Chapter 7s. About 30% of those, so 150, 200,000, close to 150 are Chapter 13 cases, right? The cases that last 3 to 7 years right now. However, making all those payments every month for 5 years or 7 years or even 3 years is difficult for people because, remember, people filing bankruptcy are people that are not generally in a good position financially, and a lot of times might have trouble, keeping their financial affairs in good order. These, most Chapter 13s are not successfully completed. More than half end in dismissal because the debtors don't pay all those amounts and don't complete all those requirements. So if say 150,000 Chapter 13s were filed last year, I would expect maybe only 50,000 of them ultimately in the entire country would be successfully completed. A good 2/3, maybe more, maybe 60,000 would be successfully completed, but most of these get dismissed. So I hope that's helpful. That's the main thing, though, is that in a Chapter 13, they have to pay. They need to pay according to the plan. Kathy, does that answer the question?
Yes, and I think when it's dismissed, that means that the stay is lifted and the association can pursue
Yes, when
the
it's
debt.
dismissed, it's as if it never happened. So you can go back and try to get the full amount. However, here's the thing. Part of the reason why you probably want to file a claim, even if the case is getting dismissed, is it might take it 3 or 4 years to get dismissed. They might be in bankruptcy for 3 years before they get kicked out. And what happens a lot of times is they're in bankruptcy for a long time. They stop paying the mortgage in the homeowners association. They get kicked out of bankruptcy, and then the mortgage company forecloses. So if you didn't file a claim, you didn't get paid for 3 years, and now the mortgage company is going to foreclose, and probably they're not going to pay their homeowners dues if the mortgage company is about to foreclose on their house. Versus if you filed a claim, you'd hopefully get payments for those 3 years. And then if they got kicked out of bankruptcy because they eventually stopped paying, well, at least you got 3 years of payments before the mortgage company came in and foreclosed. You're in a much better financial position. Now, other things to do while they're in bankruptcy is, one, you can contact their attorney. The bankruptcy stay, it protects them, but it doesn't protect their attorney. And I routinely send letters and make phone calls to bankruptcy attorneys about delinquent homeowners dues. It's not a very expensive thing to do, just the cost of having a lawyer send a letter. However, no real guarantee that their attorney does something. But when we'll talk about these other things, bankruptcy law is pretty clear. Bankruptcy law is pretty clear on what, it's not like if you're in your house or you're in your condo for a Chapter 13 case, you have to pay the homeowners or condo association. If not, And if you propose a plan that doesn't pay the homeowners association, well, then the association can file an objection or response to the plan and object and say, this plan isn't right. It's not, you're not following the law. You have to pay us the dues. And the judge will grant that objection and reject the plan. Now it's expensive because you're going to federal bankruptcy court and you have to file something with the court. We're talking thousands of dollars. But, the association's rights are very clear. If they propose not paying the homeowners association and staying in that property, that is not a, that's an objection that you would win. Similarly, permission for state court action, if, say, they said they were going to pay, the condo association, but then after a year or two, they stop paying, well, you can ask the bankruptcy court permission to get relief from the stay and go into state court and do a foreclosure. Now, you can't just do a foreclosure, but you can ask the bankruptcy court permission to do a foreclosure. And the law is the bankruptcy court has to say yes. If they're in that condo and they're not paying those condo dues, the law is clear that the bankruptcy court has to allow the condo association to do a foreclosure. However, so it's a good option if you're dealing with somebody who hasn't paid for some time. However, one, it can be somewhat expensive, and two, you're still in bankruptcy court and the debtor's lawyer knows this. So if you file one of these motions, what's going to happen is you're not just going to go to court and the judge is going to grant the motion. What's going to happen is the debtor through their lawyer is going to say, okay, we know we're behind by a year. Here's what we'll do. We'll pay double for the next year to catch up, or we'll pay triple for the next 6 months to catch up, or something. They'll propose some way that they can catch up during the bankruptcy case. And a lot of times, if they propose that, and that seems to be feasible with their income, the judge is going to deny the motion and allow them to try to catch it up by doing one of those things. Because remember, you're still in bankruptcy court. This is like home field advantage for the debtors. But if a letter to the, if they're not paying their condo dues and you sent a letter to their bankruptcy attorney and they ignore it, then you can file one of these motions. And you're gonna get your money either. I mean, you got to spend the money to do it, but you're going to either get a court order allowing you to foreclose, or they're going to do some proposal to get you paid. And usually, remember, they filed bankruptcy to prevent a foreclosure probably from their mortgage company against their house. That was the whole reason they did this. So if you're asking permission to do a foreclosure now because they aren't paying the condo dues, usually that they're pretty incentivized to try to stop that. So
on that
yes.
balance, Michael, if they haven't paid the condo dues, can the late fees be assessed against it?
Well, so this is an interesting issue. And it's kind of complicated because usually our advice is not to charge late fees in bankruptcy because administratively, there's a bankruptcy rule. It's actually called Rule 3002.1. Yes, that's literally how complicated this is, that they number the rules like that. That requires, if you've got an ongoing, like secured obligation against somebody's primary residence, so their house, their condo, whatever, you have to file notices whenever you add anything that's not the principal obligation. So you don't have to file a notice for the monthly dues, but if you're going to add a monthly late fee or something, technically, an interpretation of the rule is that you need to file that notice. So administratively, and this rule came about because banks were adding all sorts of inspection fees and winterization fees and all sorts of extra fees to people's mortgages. So at the end of a bankruptcy case, when the bankruptcy trustee would say to the banks, okay, banks, we just paid you for 5 years, mortgage should be caught up. The banks were saying, no, it's not. You still owe $5,000, and they discover $5,000 worth of late fees, inspection fees, blah, 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 right? So to stop that, they created this bankruptcy rule. And every time you do one of these fees, you have to file a notice with the court that goes to the trustee, that goes to the debtor, that goes to the debtor's attorney, that you added some sort of non-principal fee. Banks have people to do this, right? They have an entire compliance department that does this. Associations don't, and you probably don't want to contact me to have me file a notice with the court every time you put on a $20 late fee. It's just not cost effective. So that's why my advice is typically don't charge late fees, because administratively, I mean, technically you can, but to comply with the bankruptcy code, you have to file all these notices, and administratively, that's just not something you can really do.
Okay.
Or you do in a cost-effective manner.
A related question would be that this person also has a pink flamingo in their yard and we want to find them. How does that work if they're in bankruptcy?
Okay, so how that works is you can absolutely hold them, call them to a hearing, right? Call them to hearing, find them in violation. And you could maybe add and say, we're going to start charging you $10 a day. However, if they don't comply, you can't really do anything. Normally what happens when you start adding a bunch of fines, then you collect on the fines, right? Then you file a lien against their house, or you file a lawsuit against them in state court to get rid of the flamingo. Well, the state prevents you from doing anything to try to exercise control over their property. Meaning you can't file liens against somebody in bankruptcy without permission of the bankruptcy court, or bankruptcy state prevents them from being sued. So you can't sue them to take down the flamingo. So usually what ends up happening is call them to hearing, find them in violation. Then I'll send a letter to their attorney and say, hey, take down the flamingos. This is a clear violation of the covenants of the association. Like, look at this. It looks like a forest of flamingos. And hopefully their attorney can knock some sense into them and get rid of the flamingos. If not, we'd file one of those relief from stay motions to say, hey, we need to file a lawsuit in state court. And I would say that, you're more like low-level violations, flamingos, Christmas lights, trash cans, parking, a lot of times don't come to the level of we're going into bankruptcy court and asking permission to sue the people. But, if somebody's building like a pool house or a garage or something where they need permission from the architectural committee to do that, and where the covenants don't do that and they're just doing it anyway, then yeah, that's the situation where you would want to go into bankruptcy court, request permission from the court. The court is going to give you permission to go to state court on the issue, because they sure don't want to deal with, bankruptcy court doesn't deal with generally flamingos and garages and architectural stuff. That's all state court. So they'll say, yeah, take that to state court. It sounds like that's really the only way you can sort this out. And then you go to state court. Does that make sense?
Yeah, so that is a follow-up question in reference to the flamingo and not being able to take action. Is that the same in North and South Carolina?
So the same, the stay is the same in both. You have the same stay concern in both North and South Carolina, right? Is that you can't, and in South Carolina, this is all more even particularized, right? That, the documents for every association are governed what exact powers and rights each association has. But the automatic stay applies both. It's federal, it applies across the board. So generally, you're going to have to watch out for that no matter what state you're in. In terms of exactly what you should do in a particular situation and what your rights are, you really need to contact your lawyer. You really need to contact your lawyer and have them look at the bankruptcy case and see and go from there. This is kind of, you know, this is a really kind of case-by-case analysis. Anyway, are there any other questions? You know, I'm happy to, we've got some more time. I'm happy to answer any other questions. I know this is a riveting topic on a Thursday evening, but it's very, if you have to deal with it, it's good if you have some comfort, level on what this is. And also, there is a real sense of urgency to filing a claim at the beginning of the case. So if you get bankruptcy documents, I mean, if I have no other takeaway for anybody, if you get documents about a bankruptcy, give that to your manager, who will then hopefully pass it on to your attorney, or get that to your attorney and have an attorney who knows something about bankruptcy look at the case. If, you know, even if you think this looks like a, you know, no asset Chapter 7 case, I don't think we need to do anything, have an attorney look at it just in case. I mean, that is my number one piece of advice when dealing with bankruptcy, is get an attorney involved, because if you don't do anything, you know, I mean, you know, they're gonna, for example, they're gonna ask permission, you know, if somebody's selling their house in a bankruptcy, they have to ask permission of the court to sell the house, right? Well, if there's unpaid homeowners association dues, a lot of times that has to be included in the motion and in the court order to disperse to you. If it's not, you may well not get paid. And then if later on you say, well, hey, you didn't pay us at the closing of this property, the bankruptcy court's going to say, look, you were served with the sale motion 6 months ago. You had an opportunity to say, hey, we're entitled to money, and you didn't do it. I'm sorry, you're too late now. And that's a scenario where, had you responded to that motion, you would get paid. You know, the law's pretty clear. Homeowner association dues, if you get a lien, you're gonna have to pay those at closing. And there's a lot of things like that. So contact your attorney if, you know, if you get bankruptcy documents in the mail.
Yep. And Michael, I was going to say that is my takeaway is talk to your attorney. I've been doing this for about 25 years. And the first thing I learned was talk to the attorney when it's a bankruptcy. And I think that the biggest thing we get from board members is that what you mentioned is that they see that line item on the financial report for a year or more, and that gets very frustrating for boards. So you've done such an outstanding job today. You really walked us through everything from beginning to end, and in a manner that I could actually understand it. So thank you so much.
No problem. Well,
we are going to post this presentation because I know boards will want to come back to it for sure.
Great. Well, here's my contact information. You know, if you didn't feel comfortable in asking a question in front of everybody, feel free to email me, or that's my direct line from my office. You know, I'm really happy to be here, and I hope that everybody found this helpful.
Absolutely. Thank you so much. We really do appreciate your time.
No problem. Thanks, Kathy. Anything else, or are we good?
I think that's it. Yep, we will, like I said, we will record this and put it on the website for other folks. And thank you to the board members who attended. We greatly appreciate your time and for serving your community as well. And much as we like to work with you, Michael, I always say, I hope I don't have to see you because you're a lawyer, so don't take it personal.
No problem. No problem. Well, look, everybody, thank you so much and have a nice evening.
You too. Bye-bye.
Bye.